The next topic that we have taken today is NCRB data on preventive detention. NCRB is National Crime Records Bureau. It's a certain body which keeps the record of the crimes that are taking place in India. Why is it in news? Because a report was published by NCRB itself that preventive detention has gone up by 23.7% with respect to the previous year. Let's look at some background of it. What the report basically says, it says that preventive detention saw a rise of 23.7% compared to the previous year. In 2021, over 1.1 lakh people were being placed under the preventive detention. A total of over 24,500 people placed under preventive detention were either in custody. Now we'll try to understand what custody is, or still detained as of the end of the last year. Okay, now there's a difference between custody and detainment. We'll try to understand that in a while. Now if we compare that with like 5-year back data in 2017, so it has been this year's record is the highest since 2017, when the NCRB started recording this data. In 2017, 54.2% people detained were either in custody or still detained. Okay, and in 2021 this number decreased to 49.8%, with more than half of those preventively detained released. Okay, so this is the whole report. Now we will try to understand what is detention, what are the constitutional provisions regarding detention, and how it is going to, like, what are the specifics in this whole custody detention, and we'll try to understand that. If you look at the preventive detention under NSA is National Securities Act. So we can see this red one shows detentions and the blue one shows released. What we can see is from 2017 to 2021, we are observing, in 2021 we had 501 people who were preventively detained, and out of which 229 were released. But the number of people who have been detained has fallen in 2021. It is around 483. But in 2020 this figure was highest. It was around 741 people were detained under NSA, National Security Act. Okay, so this shows the data of detention under National Security Act. Among other laws under which the NCRB also records data on preventive action, first one is Gunda Act, State and Central, 29,306 people. Prevention of illicit traffic in drugs and narcotics and psychotropic substances, 1988, 1331, and other detention acts. Apart from this, most of the people were detained under other detention acts, 79,500 people act. 79,514 people. Okay, so this gives you a picture of what the scene about preventive detention in India is. Now we'll try to understand what is a preventive detention, what are the constitutional provisions for it. Okay, so detention in the simplest term is taking a person away from his liberty without his consent. It can be legal, it can be illegal, right? But in both the cases, the person will most likely not consent to be detained, right? So there are two types of detention. The first one is preventive detention. The second one is punitive detention. Preventive detention means taking a person into custody prior to the commission of the offense. The offense has not been yet committed, but there is a chance that a person will commit a certain offense, and to prevent that person from committing that offense, he has been taken into the police custody. That is preventive detention. On the other hand, punitive detention means to take a person's liberty away so that he can be brought to justice, he can be punished in accordance with the law. That is called punitive detention. So detention fundamentally does not mean preventive detention. Okay? So there is a difference between detention, arrest, custody, police custody, judicial custody, and we try to understand it. But the fact is, Detention is of two types. The first one is preventive detention. The second one is punitive detention. In preventive detention, we the police is or the law enforcement agencies are trying to prevent a crime from occurrence. Okay, that is, they are anticipating a person to commit a crime and then they are arresting him or taking him into custody to protect him, to prevent him from committing that offense. On the other hand, punitive detention is when a person commits a crime and he has been convicted, and when a crime has been committed, right? So after a crime is committed also, the person who is charged is not guilty unless the court has determined his guilt. Okay, unless the court has determined his guilt. So a person who after the commission of crime is arrested, that is also punitive detention, because the crime has already happened. Whether the person is guilty or not, that will be assessed or determined by the court. But during that period, the person is held up in police lockup or in jail. That is what punitive detention. Okay, that means the person's liberty has been taken away for enforcing some punitive action on him. Okay, so let's try to understand what are the rights given to people under punitive detention and rights given under preventive detention. Now, in punitive detention, what the fact is, in both the cases, the person has the right to know as the reason for his detention. The first and very fundamental fact. In both the cases, the person has the right to know as to what kind of why he has been detained. But there's a peculiar catch in the second one, that is in preventive detention. The police or the law enforcement agency can choose not to divulge certain information which can lead to which can compromise the national security, okay, or law enforcement as well. Okay, so he can be that is specific provision in the preventive detention. That means the law enforcement need not divulge such information which can compromise national security or law and order. So in such cases, if the law enforcement thinks that this information is very confidential or such that if divulged it can lead to the compromise of law and security or disorder, in that case the law enforcement agency can withhold certain kind of facts from the person who has been detained. But that is not the case in punitive detention. In punitive detention, the person has absolute right to know as to what has been basically as to why he has been arrested, okay, or why he has been detained. Actually, the person who is detained or arrested under punitive detention, they have the right to access of FIRs as well, right? In both the cases, the persons who are detained have the right to be consulted, to consult a person, a legal professional of his or her own choice. In both the cases, right? Both have the right to choose a legal practitioner of their own choice. When a person is detained, right? When a person is detained, in that case, he must be produced to a nearest magistrate within the 24 hours of his detention, right? But in punitive detention, that is not the case, because if in punitive detention only two things happen. The first one is either he is given the judicial custody or he is given either he is sent back to jail or he is given the judicial or police custody. In punitive detention, like if a crime has already happened. But in preventive detention, if a person is being detained, he must be produced before a magistrate within the 24 hours of detention, and the magistrate can then decide upon the fact whether he is to be put into the police custody or judicial custody, right? Now, let's talk a bit about arrest, detention and custody, right? What is custody first of all? Custody means to take take someone into protective care, in the very simple words. Like if you are a teacher, so you'll be having the custody of the kids that you are going to teach. So that is the very basic meaning of custody, right? When a person is detained, he is brought to the to the magistrate, okay, to the court, and then magistrate decides as to what he should do. Either he can put that person into police custody, or he can put the person into judicial custody. In police custody, the person will be locked up into a lockup, or the police station lockup that is called police custody. The police can demand the police custody in case the police wants to interrogate him, okay. And in the judicial custody, if a person is sent into judicial custody, that means the person will be sent to jail, and the magistrate who is ordering his judicial custody will be the person responsible for his well-being, okay. So that becomes the basic difference between police custody and judicial custody. I am explaining because in very recent years there were some questions regarding these as well, like what is the difference between bail, and what is the difference between bail and certain kind of such type of things. So it is of general understanding, and there is a lot of always a buzz about police custody and judicial custody. Then I thought this should be explained. On the other hand, detention versus arrest. A person who is arrested, okay, a person who is arrested is when police take away the person from his liberty to investigate the crime, okay. On the other hand, detention to question him in a specific certain manner, like specific matter of crime, okay. And for detention, only reasonable suspicion of crime is important, but for arrest, strong evidence is required. For arrest, a warrant is required. For detention, a different kind of warrant is required, where the suspicion of the police is sufficient cause for detention. But for arrest, not suspicion, but strong evidence is required, okay. So that is the basic difference. Now let's talk about what are the constitutional provisions regarding the detention. Article 22 talks about detention. Article 22 talks about the detention. It provides, Article 22 is a fundamental right. It provides every individual with protection against arrest and detention in certain matters. Now Article 21 talks about the fact that any person cannot be denied the right to consult and to be defended by a legal practitioner of his choice, both in preventive detention and in case of arrest as well, okay. But it allows for preventive detention and restriction on personal liberty for the reasons of state security and public order. Now this is a very important point to note here, that preventive detention can be allowed. Preventive detention can be allowed on the grounds of state security and public order. That is the important point to note. Now Article 22(4) says that no law providing for preventive detention. No law providing for preventive detention means, the confusion that students have is that Article 22 talks about detention and it says how a person should be detained. That is not actually the case. It talks against the detention. It talks about the right of people who have been detained, okay. So who can provide for laws for detention, preventive detention? Both state government and central government. So if there is a law which provides for preventive detention, so it's the original law said, the Article 22 clause 4 said that no law which provides for preventive detention shall authorize detention of a person for a period longer than 3 months. No person can be detained preventively for a period longer than 3 months except an advisory board reports sufficient cause for the extended detention. Now advisory board is a specific body which contains the judge of the respective state, the high court of the respective state, okay. An advisory board is formed to look into the specific detention, and if the state wants to detain the person for a period more than 3 months, they will have to take the permission from the advisory board, okay. And such a person is detained in accordance with the provisions of law made by the parliament, okay. If some specific law provides specifically for a detention more than 3 months, then it can also of course be done, but advisory board's permission is required, okay. Now the 44th Amendment 1978 what it did was it curbed, it shortened this 3 months period to 2 months. It shortened this 3 months period to 2 months. But the fact is, the unfortunate fact is that it was never implemented, hence it was never brought into action. It was not notified by Gazette. Notified means it has not been brought into action. So still the period is 3 months. Okay, the period for detention is 3 months, despite the fact that 44th Amendment Act 1978 has brought the period of detention from 3 months to 2 months. Okay. Now we'll talk about what are the specific powers which governments can make laws for preventive detention. The first one is concurrent list entry 3. Now concurrent list, that means both state governments and central government can make a law for prescribing preventive detention for the issues of security of a state, the maintenance of supplies and maintenance of public order. Okay, so in these 3 cases, both the central government and state government can make a preventive detention law. But in case of some certain issues like national security, defense and foreign affairs, okay, defense, foreign affairs or the security of India, so the power of making a preventive detention law under such issues lies is exclusively with the parliament. Okay, and only parliament can make laws regarding the advisory boards. The only parliament has the power to make a law regarding advisory boards. Okay, now there are various laws prescribing preventive detention. Of course, the National Security Act, National Drug and Psychotropic illicit trade in drug and psychotropic substances act. Okay, Maintenance of Internal Security Act, which was repealed, MISA, and POTA, Prevention of Terrorism Act, which was also repealed in 2004. Okay, so these are some specific laws which provide for preventive detention. I hope you understood this whole concept of preventive detention. Now I will try to jot down the specific pathway through which we understood the preventive detention, so that when you revise it, it becomes easy for you to look for what you have to study into this whole preventive detention thing. What we did was, first of all, we read the NCRB data on preventive detention. Then we tried to understand the constitutional provisions on PD, preventive detention. Then we tried to understand the different kind of detentions, okay, and also the difference between arrest, custody and detention. Okay, arrest, custody and detention. And then we tried to understand what are the powers of specific governments, basically state government and the union government or parliament, okay, to make laws regarding preventive detention. And basically what we did in that was we list entry 3 of concurrent list, and then entry 9 of union list. Okay, so this is how we try to understand this whole topic of preventive detention, and I believe it covers everything about preventive detention. It is very exhaustive. There is nothing else to study. Okay, apart from Article 22, which you should go through, and Article 20 as well. So I believe you have understood this. If you have any doubts in this, you can kindly ask me in the comment section.